What is the most common CFIUS misconception?
They don't mean to reject every deal that comes through. In fact, the majority, I believe, are approved, if not the vast majority. In China, you can find an agent to help you do a filing for almost any kind of regular filing. There is an agent that does 外汇管理局75号文的代理. And in the US, there's really not anything quite like that. There's an expression in English says time kills all deals.
Say there's a Chinese old saying like 欲速则不达, haste makes waste.
But once they get big enough here in the US, they will be a victim of their own success. When TikTok got bigger and bigger in the US, people are like, what is this TikTok? Like, who controls TikTok, right? Or Shein, right? Like, oh, they're getting all this personal information about us. Who is this company? Wait, is it a Chinese company? What is it, right? So these brands need to define themselves before someone else defines them.
What are the governance traps they most often fall into? Shareholders' agreements, board composition, fiduciary duties. Where's the most common blind spot?
Corporate governance is done in the US by and large to protect the decision makers from lawsuits, essentially, and liability. And that means having decisions documented, as I posted videos about. Even if you already know what the decision is and you've talked about it offline, you've talked about it over lunch with somebody, and you still need to document why you made a decision, the reasons, and you need to document that you took the time to do the proper analysis. I think that that's a real opportunity for a boutique firm. I mean, for our firm, we've all worked at big law firms before in the past. The big thing that makes us unique or our advantage compared to the big law firms is that we don't have the overhead that they have. We pass those savings on to the clients. Many clients don't need the big law firms to service them. And that's where we excel. We don't, we're generalists, so we can help them on a lot of stuff that they see day to day and transactions and setting up a company. And if we need to find, if they have a very specialized request, let's say they have to make a regulatory filing in front of an agency, we wouldn't have that experience, but we can help them find someone with that experience at a better rate.
Thank you very much for joining me.
Thank you, Lee. I mean, it's a pleasure to be on your show. And my name's Art Digger, and I am the managing partner of Parkwyn Legal. And I've been a practicing lawyer for over 20 years now. I started out in New York, working at a firm there doing corporate transactional work, M&A, private equity deals as a very junior lawyer, and just starting out. And then I got the chance to switch to a different firm, Morris & Forrester, and I went to their Beijing office in 2007 and was there for the Beijing Olympics. That was great. I was there till I was a 6-year associate, and I went in-house to a client of the firm called Cadence Design Systems, which is a software company that's for semiconductor design. And I was their Asia Pacific general counsel for 6 years. That's moved me down to Shanghai. We had about 1,000 employees in China, and so I got to learn everything, how a company works and how a U.S. company operates in China from the inside, which was nice, different perspective. And after that, I went back to private practice briefly for a Chinese law firm, but still helping American clients in China. And then a little over 3 years ago, I moved back to the U.S. and settled here in San Diego. And I set up my own firm, and we do a lot of cross-border work. We have American clients, but we also have Chinese clients who are interested in expanding here in the U.S.
You've been a corporate lawyer in China and a regional GC at a tech company, and now a managing partner in San Diego running a boutique firm. So that is very unusual path. You also hold your podcast. I noticed that you post videos on WeChat and providing your insights into U.S. law. So which of these roles gave you the most insight into what Chinese companies actually get wrong before or when they enter into the U.S. market?
Yeah. So there's actually one part of my career that I didn't mention, which was in between when I was at Cadence, the American software company, and when I was back at a firm again, I actually started my own company, which was helping Chinese companies expand overseas. Wasn't a pure legal job. It was more just like business and strategy advisory work, along with two other fantastic partners. That was the first time I really worked directly with Chinese companies as clients, even though most of our clients were American clients or international clients. I had Chinese clients that I brought to the firm. A lot of them were in the semiconductor industry. So that was my first real experience working with them. Of course, I speak Chinese and I can understand it. Going back to when I learned it in university as an undergraduate, I had maybe slightly more like Chinese friends than the average foreigner that lives there and a lot of colleagues. I was involved in the American Chamber of Commerce. And so I was meeting a lot of Chinese lawyers over the years, whether it was on my team or at the firm I used to work at, or just out in networking and stuff. And then through the podcast, the China Business Law podcast, that was primarily interviewing Chinese lawyers about cross-border legal issues. And so I got more familiar, I think, with how Chinese lawyers think, their background, their training, and then also how Chinese companies think from all of those experiences. But the podcast definitely helped a lot because that was really interviewing a lot of Chinese lawyers.
So what is one like deal or situation where you realize that this client has fundamentally misread how American business and law work?
It would be a number of cases. It wouldn't be one particular case. There are Chinese clients which, if it's their first time looking at the U.S. market or entering the U.S. market, there's just so much they don't know. They don't know what they don't know, like we say in English, right? One thing that comes up a lot is they don't, and it's not even purely a legal issue, but they don't know how to build a brand in the US. I think it's very similar to what US companies face when they go to China. They really have to reinvent themselves, and they also build nobody knows who they are here in the US, right? So that's just on the very upfront, getting some brand value and some goodwill from the local community, understanding the regulators that you're going to have to know and interact with, and get from in before you even get familiar with the laws and the regulations here. I think Chinese companies are cautious also because they know that they might be under more scrutiny than local companies. And again, it goes back to that's just the same thing that happened to American companies when they were in China, right? A lot of American companies, because or any foreign companies operating in China, we always used to think that the laws, not that were more strictly enforced against those companies, but just the regulators were more careful to look at what they're doing, and those companies were more careful not to do something wrong. And I think for Chinese companies coming into the U.S., they are much more aware now that the U.S. legal system is totally different. The regulatory system is different, and so I think they've learned that they need to take it slower than they might otherwise want to and take a more careful approach. So I think that's been a big change I've noticed over the last few years as well.
I noticed that you wrote several influential articles on CFIUS and Chinese investment in the US, but in the US, like back in 2018 or 2020,
Yeah.
when CFIUS reform was still new. But now in 2026, with reverse CFIUS also in play, now looking back at what you wrote, did reality exceed your predictions, or what did you get right, or what surprised you?
Well, so the reason I was so interested back then, especially, was that business we were doing was helping Chinese companies look at targets to invest in or acquire in semiconductor space or an automotive or robotics and stuff. And those are
Mm,
exactly the areas that the revised CFIUS was looking at more carefully. And before that, the CFIUS that had been the law forever had a lot of honestly just had a lot of holes in it as far as certain ways that you could structure a joint venture that CFIUS wouldn't really would fall out of the scope of CFIUS. Certain kinds of licensing deals or asset deals. And so when that new law came out in 2018, they plugged a lot of those holes in the law from before. And it really made it very difficult. And so I don't know if I was so surprised. I mean, I remember reading a draft of that law a year before it was finally passed. And it was just a draft that was being circulated around for comment in the community, in like the legal community and so forth, and in Congress. And I just read it and I said, that's it. It's done. Like Chinese companies never going to be able to acquire a US semiconductor company now. I don't think I was surprised by that. I don't think most people that were really in that space doing cross-border M&A were too surprised, just because it was very clear the way it was written and the intent, the debate. I think it was like a JV agreement between AMD and the semiconductor company and a Chinese company. I want to say it was in like Sichuan or something like that for their R&D or something. And the regulators, the Congress was pointing to those kinds of specific cases as like, this is a deliberate attempt to get around the CFIUS rules, and we need to fix this. So when they do that, they mean to really stop the cross-border M&A and VC investment. There was so much intent for the regulators to do that. So once the Congress really makes up its minds about that, it's really hard to find loopholes in the rules if they really try to draft something that's complete like that, like FIRMA.
I think many Chinese companies investing in the US often think that CFIUS as a government reviews for big deals or important industries. In your experience, what is the most common CFIUS misconception? Like the thing companies assume won't trigger a review, and then it does.
There's certain cases where there's a mandatory filing, right? Certain kinds of technologies. But I think the misconception is that just because you have to file, that it's automatically going to get rejected, right? In fact, in my own podcast, I've had people come on who have worked at CFIUS before. CFIUS is not its own agency, but people have worked at, let's say, the Treasury Department or the Justice Department as part of the committee for CFIUS. Even from folks that have worked on the inside within, CFIUS, they still very, adamant about the fact that they don't mean to reject every deal that comes through. In fact, the majority, I believe, are approved, if not the vast majority. So I think just because you have some concern that it's going to be triggered, it depends at that point really how much you want to do it. Of course, it is a risk. We can often have to unwind the transaction. But if there's enough reason to do the deal, it is a hurdle that you can get past in a lot of cases. So I think that's a misconception oh, this might trigger CFIUS, so we can't do the transaction. I mean, in fact, that's not necessarily true at all.
You mentioned the word agent. Do we have like in the United States that we have a 中介 of that kind to help the investors to file for that review?
For that case, you would really use a law firm for that. That's a very specialized field, and you have a lot of the people that are, do that practice full time have previously worked at those agencies as internal lawyers for, let's say, the Commerce Department, the Justice Department, the Treasury Department. That is one thing that actually comes up a lot as well. In China, you can find an agent to help you do a filing for almost any kind of regular file, including like 七十五号文, right? The safe filing, I think, for overseas investments, right? Like there is an agent that does 七十五 外汇管理局七十五号文 the 代理. There's like a specific agent that can do that. And in the US, there's really not anything quite like that. You do have consultants, which will help you review the application. You do have lawyers, which will look at it if it's really like very specific about the regulations and stuff. But like a specific agent that just helps you do the filing, don't quite see that much. And that comes up a lot of times as a point of confusion for Chinese clients because they're used to what they have in China, which is okay, I just need to find the agent who knows, like which window do I go to at the, 哪个窗户 do I go to submit the application? And then you've got it. It's just so much easier that way. I get clients asking for that all the time. It really doesn't exist in the same way here in the US.
Applicants always go to the law firms, right?
Yeah, which of course is that's a that's a kind of an unpleasant surprise for Chinese companies because obviously lawyers are much more expensive. We charge by the
Mhm.
hour.
And let's move back to some issues more general. So,
Mhm.
I've noticed you post several videos on WeChat about the corporate governance. So
Mhm.
when the Chinese investors take a stake in the U.S. company or bring in a U.S. partner into their U.S. subsidiary, what are the governance traps they most often fall into? Shareholders' agreements, board composition, fiduciary duties. Where's the most common blind spot?
Yeah, I mean, I think there is it's still not as common as people think to have like joint venture arrangements for that. For example, where you have a two investors from different sides. That's growing. And I think the corporate governance, I think the mentality in the US is slightly different about corporate governance. Corporate governance is done in the US by and large to protect the decision makers from lawsuits essentially and liability. Yeah, of course, you have a board in Chinese for Chinese companies in China, and you have a way that decisions are made. But in the U.S., especially when you have shareholders from different sides, let's say for example, you said a U.S. shareholder and a Chinese shareholder, or especially when you have kind of an internal team with the founders and those shareholders, and then you have external investors, maybe venture capital investors, but some external investors. You want to make sure that corporate governance is good, and that means having decisions documented, as I posted videos about. Even if you already know what the decision is and you've talked about it, offline, you've talked about it over lunch with somebody, and you still need to document why you made a decision, the reasons, and you need to document that you took the time to do the proper analysis, right? If you're going to sell a major part of the company, for example, right? Let's say you're going to sell a division of the company or something, you need to have made shown that you actually did like a proper process to get a valuation on that company, or that you did a proper process for finding a third party buyer, right? Or if you making if you're issuing stock to someone, or you're doing employee stock option plan, or whatever major corporate decisions, you can't just make those over WeChat and say, "Okay, it's done," right? Like sometimes might be the case more informally in China. You need to have an email track, you need to have board meeting minutes and all documented, all for the purpose that someone later on says, "I think you didn't do this in a fair way." So you're protecting the shareholders, because even in the US, even the shareholders, majority or controlling shareholder have a fiduciary duty. Certainly, you're protecting the board of directors and then the senior officers from liability.
So the key is documentation of all the decisions and
Yeah.
the analysis before that.
Yeah, and that comes up a lot too, because a lot of times, and I think this is one that throws off Chinese clients quite a bit. Um, one of the key principles of fiduciary duty in the U.S. is a duty of loyalty and a duty of care. Those are the two primary ones. Together, it's basically like a duty of good faith, and that means that you put your company's interests ahead of your own personal interests. And so a lot of times, I know Chinese companies, of course, have a lot of what we call related party transactions, right? Where there's some relationship to both sides of the transaction. There's some connection there. Could be a family connection, could be joint ownership or something. But if there's a third party investor, let's say, involved in one of those companies, right, then that you have a fiduciary duty as a board member, or in whatever capacity, making those decisions to make sure that it's done in the best interest of the company and not in the best interest of the people with that have that conflict of interest that we call it, right? If they're on both sides of the transaction. And that, I think Chinese companies certainly understand it when you explain it to them, but they maybe not as aware that, like, we need to document that this was what we call arm's length, fair transaction, properly priced, right? The same you'd get as the market price from a third party, just to protect yourself from someone challenging it later on.
Before a Chinese company he is about to establish a US entity, like sign an agreement with a US partner or taking on a US investor, what is the like legal groundwork that most of them skip or ignore and then later regret?
Well, honestly, the most common case the day-to-day case we see is simply just a Chinese company setting up a subsidiary here, a 100% owned it's a 公司, a subsidiary that they fully own. And even in those cases, right, they're a lot of times it's just little things, like they'll find somebody to set up the company themselves and they won't go through a law firm or a kind of someone who's more experienced to help them do that. So they get some of even just the basic governance documents wrong, and or they won't think of, again, properly documenting it all. You really need to think about what state do you want to incorporate in, because in the U.S. it's by state, right? You and then getting set up, you have to get the tax registration and all that kind of stuff. And also when you start hiring employees, a lot of things that a foreign company that we always used to see in China, right? You need to have a employee handbook. You need to have proper policies on sexual harassment and anti-discrimination. And there's so many rules about once you start hiring employees, which most of them will, of course, once you start hiring employees, there's a whole brand new world of regulations and laws that you now have to be familiar with. And I think sometimes it can be a lot for Chinese companies, certainly to do it themselves. And so you really do need a law firm or some other advisor helping you with all of that stuff. So I mean, that's even before we talk about, like you mentioned, dealing with a US partner or US customers, and you have to say customers, you have to start collecting sales tax in every different state. It's like the sometimes the drawback of the US is that we have 50 different states, and if you're doing business across the country, it can get a little more complicated.
When you are sitting at the negotiating table with a Chinese company on one side and the US company on the other side, what are the negotiating dynamics that constantly created problems, misunderstanding? Are they legally, or culturally, or something else?
In the end, it comes down to somewhat of a lack of trust, right? And that's the mirror image of US companies going to China. It's the same tension there. Um, so you can, document that. And like when we did joint ventures for US companies setting up in China, right? Like it's very important who has control, right? Sometimes you might do the control where someone is the general manager, but someone else gets to appoint the CFO, and so you have kind of a checks and balances there. And I think that's same general principles for here in the U.S. with a Chinese company, right? A Chinese company might be bringing the capital, might be bringing the technology. The U.S. partner, it's the opposite of China, or what we used to see in China. The US partner will be bringing the local know-how, marketing, sales channels, distribution, and putting a local face on to the products. It's the same problems that we always used to deal with in China for American companies. You have to find some way to have control over the board of directors be fair and without one party having too much control over the other party.
There is a typical scenario. A Chinese investor is building a company in one state of the US, but he would like to expand their business across what requirement are they about to meet? Company in one state, but business all over the country.
You don't need to set up 50 different companies in each state.
Okay.
That's not practical, of course. Then they don't do
Mhm.
that. But you would have typically a lot of times companies will incorporate in Delaware starting out because Delaware is a very long history of judicial decisions about corporate matters. And Delaware just has a good reputation as being a place to set up a company. So a lot of people do it there, but they don't have their business in Delaware, right? And then they'll have their headquarters in California. So you'd need to register your company in California and that's fine. You just represent as a foreign, we call it a foreign company, but like basically an out of state company. And
Mm-hmm.
then as for the other states, it really depends how much of a footprint you have there, right? I mean, if you're just selling a few transactions in there, you have to kind of figure out the sales taxes in each state and that sort of stuff. But it also depends on your product, right? It depends on your product and how much of a footprint you have. Do you have an office there? Do you have employees there? But you don't need to set up a company in 50 states. That would be totally impractical.
I'd like to talk about the hiring of a U.S. lawyer. So when Chinese companies hiring a U.S. lawyer, what do they need to prioritize? Like do they need to prioritize Mandarin fluency or China experience? In your view, when is that the right call, and when is actually
Yeah.
the wrong thing to optimize for?
Of course, it's in my interest to say it, but I do think it is helpful to have a lawyer who has, speaks Chinese, who has lived in China, ideally, just because I think there's a lot of cultural nuances. I use that example, where I arranged a call where a Chinese client was trying to do, I think it was an EPA filing or something like that for environmental standards, and we found an expert who knew that very narrow, specific part of law. But even in English, they were not understanding each other, and I think that's where the whole idea of the agent came up, right? Like they're asking, can I get an agent to make this filing? And they said, can you be my agent? And they're like, no, we're a law firm. It's not what we do. We don't make the filing for you. We can just give you advice about it. And that took like 15 minutes for them to figure out what they were talking about with each other. So that happens a lot where you don't have someone like me or someone else who's lived over there. No, I know where they're coming from, why they're asking that question, because that's common in China, and I know why they're confused because that's not common in the US. And so they don't even understand the assumption behind the question or the starting point behind the question. So that's why I think it does really help. You can go to a big fancy law firm where the billing rates per hour are for young lawyers is $1,000 an hour, 1,500 up to 2,000 for senior partners. They have a beautiful practice. They're going to give you all the specialties you need: EPA, CFIUS, FDA, all the different agencies you're ever going to need to deal with, and tax and everything. But most Chinese clients either can't afford them or don't want to pay those rates. And that's just reality. In China, the market for Chinese lawyers I know is incredibly competitive. And so I know there's a lot of pressure on rate. There's a lot of pressure on Chinese lawyers, cutthroat pressure, 很卷. I don't know if 卷 is the right word,
Mm,
but 紧张, the 紧张很激烈, right? Like the competition is fierce. And
okay.
and I think Chinese clients, when they come to the US, they're used to sending requests out to multiple firms, bidding and trying to get the lowest price, which I understand why they do that. But a lot of US lawyers really don't like to work that way. And so that is a big source of friction I see too. A lot of Chinese clients when they're new to the US, they will ask 5 different law firms to put together a proposal. And for those 5 firms, we pretty quickly can figure out that they're doing that. Just by the way that they've asked for certain kinds of items and so, and the way they've come back to and say, oh, well, we've got a lower price in this firm. And sorry, I'm going on a long tangent here, but one of the big things that really I think is a big source of confusion and friction between US lawyers and Chinese clients is that US lawyers, we tend to value, of course, we know we need to be competitive on price, but we think in the end of the day, you should work with someone that you trust and someone that will do a good job for you. And yes, of course, you would never hire me if I was twice as expensive as someone with the same experience and everything else. But if we don't think the final decision should be about, who exactly has the lowest price, because we think that the other things, personal fit, trustworthiness, and knowledge is more important. And the price differences will work themselves out. I think a lot of the US lawyers that work with Chinese clients tell me sometimes they will not work with Chinese clients anymore because the US lawyers were felt like they were treated with disrespect and treated like I don't know, like a commodity, like, well, this lawyer, I just need a lawyer and I'm just going to take the lowest price. And I don't care if this one has 20 years experience and this one has 5 years experience. I just want the lowest price. And so for that lawyer with 20 years experience, to them, they're like, I'm worth it, like I'm more expensive, but I'm worth it. And I think that's something where Chinese clients haven't gotten comfortable with realizing that difference in experience and therefore difference in cost.
Yes, and I totally understand. And the word "juan," it is
Mhm.
the right word. And also, by culturally, when I mean, in the Chinese deal making, a signed contract is often beginning of a relationship, not the end of the negotiation.
Right.
And some of my clients tell me that we signed the contract, but we expected that when something changed, something pops up, we'd like to renegotiate. So,
Mhm.
what is the situation um, in the American practice? Is that how it works?
Generally, no. You have contracts in the US are definitely longer than contracts in Chinese, and that's not just because Chinese characters are smaller than US words for the same amount of space. It's really US contracts are very detailed, very precise on the language, and that is because both sides go back and look at that language of the contract, and they fight about it in the beginning because they know that lawsuits in the US are much more common here than they are in China, and that um, and the other party will not be afraid to sue. Certainly, if enough of money is at issue and in dispute. So um, contracts are made to either avoid litigation. They don't like things to be unclear, and if another party wants to change it later on, that they better have a lot of leverage, to because the original party will not agree to that. I have no reason to agree to that because that's what the contract says. So it is a different mentality. Now, of course, if the other party is going to go bankrupt and you genuinely believe that, right? Or if another party, there's a change in circumstances, right? The other party can't perform or for any reason. Certainly you can always go back and amend a contract, and that happens fairly often too. But one company will, not be afraid to sue the other company if they want to change the deal and they're not performing.
Let me flip it. Is there something about how Chinese companies structure deals or protect their interest that you think American companies or lawyers could actually learn or adapt?
I'll say this. I think US companies sometimes take too long to get contracts done. You can sometimes take it too much to the extreme where at some point the value of continuing to fight over each little provision in the agreement is maybe not worth it anymore in if you're causing friction among the parties or if you are delaying the start of a transaction. So I think there is something to be said for the Chinese style of, look, it is the starting point. Both sides are going to manage this relationship, right? It's more about, do I trust this person, right? Have I gotten an introduction maybe from someone else? Is this a party that I have trust with because we have a mutual friend, right? Or something like that, or an introduction. And I think that that's very valuable and sometimes is more valuable than simply having a binding contract about something. I don't know if it's not necessarily because of the way things are done in China, but I do think we are in that sense like the way we vet, a partner for a transaction. It's not just about like what documentation did they send us in the due diligence. More and more companies are calling and doing reference checks, right, on the background of the CEO of the other company or the major shareholders, or finding an introduction that someone that as a reference that can vouch for that person. So I think people are realizing that that's just as valuable as having a solid contract in place.
I would say that, but China is adapting a way that moving too fast, internally or externally. Like in some of Chinese companies, what we call a 大厂, like big companies, internally they are moving things too fast, they're driving people crazy. A, an idea pops up at night, and they want them landing next morning. So
Yeah.
they were trying, like driving people crazy. But I would say that if we could find a balance between driving people crazy and doing things too long or too slow, when we could like find a middle sport, I think it would be more effective.
There's an expression in English says time kills all deals. In other words, if you let the deals drag along too much, something is going to come along that's going to, kill the deal the longer you stretch it out. So I agree. I think you have to try and move quickly when there's momentum to do it. And the longer you take on the contract draft and negotiations and drafting and internally reviewing those drafts before it goes to the other side, it adds up and it does kill a lot of deals.
There's a Chinese old saying like 欲速则不达, haste makes waste.
Yeah,
So
that's kind of the other way around. Yeah.
if you could sit down with every Chinese business leader entering the US market for like 1 minute, not talking about the lawsuit legal framework, but about building a business, what is one thing they almost always overlook?
I think, and again, it's not a legal issue per se, and I alluded to it a little bit in the beginning. I
Mm.
think a lot of Chinese companies have a natural instinct of I don't want to disclose the ownership structure. I don't want to have be too public with what we're doing in the US. It's not that we're doing anything wrong. It's just that I don't want the someone watching us from the US government or state government or somebody and then taking what we do and taking it out of what we say out of context, right? Like trying to say, "Oh, look at what they're doing over there," and Chinese companies shouldn't be doing that. Where, they just want to do business, right? They have no political motivation behind anything that they do. They just want to do business. But because of that, they should stick their head down, hide, and not say who they are. And that can mean to branding on a website or PR, like having public relations, with meetings with the local mayor where they're setting up, right? Or talking with the local community, going out and sponsoring some event in the community and get their name out. People say, "Oh, well, who is this company that's sponsoring, helping our kids do this or that?" Right? And these are really missed opportunities. I know it sounds silly sometimes, but that's what American companies do, right? And that's where they get their people. People then, when something comes up about a company, they know who they are, and they say, well, I think they try and do the right thing. And so with this whatever happened with this one bad employee or this bad thing in the news, I'm sure that was just a exception, right? Because most of the time they're a very responsible company. And where do they get that impression? They get it from community building and good public relations and media coverage, right? Positive media coverage. But to get positive media coverage, you have to be open, and I think that a lot of Chinese companies are not willing to open up to to media, to the press coverage, to who they are and their story. And I think that later on, that might work in the short term. Okay, nobody knows who they are. But once they get big enough here in the US, they will be a victim of their own success, we say in English, meaning there's nowhere to hide at some point, and people will see what they're doing. So, like, for example, right, like, when TikTok got bigger and bigger in the US, people are like, "What is this TikTok?" Like, who controls TikTok, right? Or Shein, right? Like, like, oh, they're getting all this personal information about us. Who is this company? Wait, is it a Chinese company? What is it, right? So these brands need to define themselves before someone else defines them.
You mentioned that those fancy law firms, international law firms, and those lawyers will have a very high hourly rate. But as a boutique firm, what is your strength?
These big law firms are not well suited to work with Chinese clients. First of all, because their rates are so high. The
Mhm.
second, they're very inflexible, not flexible about discounting those rates or doing fixed fees. You know, Chinese clients, of course, these days, American clients like fixed fees too, but
Mm.
Chinese clients in particular like fixed fees. And a lot of big law firms, especially, really just don't like doing that. And they've never liked doing that. I think that that's a real opportunity for a boutique firm. I mean, for our firm, we've all worked at big law firms before in the past. The big thing that makes us unique or our advantage compared to the big law firms is that we don't have the overhead that they have. They work in big fancy office buildings downtown. Our team is dispersed, right? We don't have a centralized office because we don't need one these days. We don't have um fancy website, or we don't have a marketing department, right? We don't have we don't go out and sponsor major, you know, events to get uh, publicity, because we don't spend all of that money, what I just call overhead. We can offer a lower fee. We pass those savings on to the clients. They may have requests that are more routine, or don't need like a lot of different specialized lawyers helping them, and that's where we excel. We don't, we're generalists, so we can help them on a lot of stuff that they see day to day on transactions and setting up a company. And if we need to if they have a very specialized request, let's say they have to make a regulatory filing in front of an agency, we wouldn't have that experience, but we can help them find someone with that experience at a better rate.
We have the similar philosophy of this.
Yeah, no, that's great. I think that's a lot of clients want that these days. Definitely.
Exactly, exactly.
Mm.
Yeah. And um, mm, do you have any questions for me?
What's been your experience working with, as you're working with Chinese clients doing cross-border work, but also foreign clients? What's your experience about the difference between foreign clients and Chinese clients?
There are many differences, but I would say the main ones are the foreign clients focus on the procedure. They
Mhm.
want every steps taken uh, are are good informed, and all decisions based on analysis. And before any actions taken, they need to go internal analysis and making decision making process.
Yep.
Sometimes it
Sounds
takes
very
a little
familiar.
bit
Yep.
longer. So when we made the proposal of next steps, actions, it would take like 2 or 3 weeks to come back. But Chinese clients, they focus on the efficiency, or once the decision is made today, they want to see the
Mhm.
result tomorrow. That is a great pressure on us.
At the end of the day, I think Chinese law and US law are actually not that different, especially if you talk about commercial and corporate law. Um, so when I work with Chinese lawyers, a lot of them have also been educated in the US, right? They've gotten like an LLM here, or they've gotten even a JD here, and have taken maybe a California bar, New York bar. And so just that, even if they never practiced here in the US, I think a lot of times, from a legal perspective, we speak the same language. So of course, for me, it's always easier to work with the Chinese lawyer in China on a transaction as part of one team, right? That's the best, because even if someone is on the other side, of a transaction, it's helped so much if like for me, that I've lived in China, and for them that they've studied in the US before. um, which just makes everything easier. So I think that's one nice thing because there've been a lot of lawyers that have American lawyers that have worked in China and come back now, like me, and there's been lots, of course, even more Chinese lawyers that have studied in the US and gone back to China.
Thank you very much. And also, I would like to see more and more of your videos posted on WeChat. So I have learned a lot
Yeah.
as well. Yeah, and I would
I've
happy
enjoyed your
to.
video interviews as well a lot. Yeah. You do very high
Mm.
quality videos. So I appreciate that.
I think that's all for today. And thank you again, Art Decker. I would very much look forward to join your show. Okay.
Yeah. We will do that. Definitely. Yeah.
Yeah. And
Sounds great. Thank you, Lee.